Hello students, in this video lecture I'll discuss with you paper 5 business laws and ethics model question paper for June 2024 attempt. Tomorrow onwards CMA intro examinations are getting started, so every one of you are busy in revising paper 5, right? So this video will definitely help you in reading the question paper in the examination hall, understanding the question paper in the examination hall. See, not only a discussion of this paper, I'm also going to give you tips regarding presentation in the exam. Once again, I'm telling you how many hours you spent on revision, how many days you spent on preparation. Everything is immaterial. 3 hours of presentation in the examination hall decides your fate. Understood? So those 3 hours are very crucial. And 3 hours how to utilize everything I'll tell you in this video lecture. Is it clear? See, paper 5. In paper 5 we are having two sections. Section A, multiple choice questions, no choice, you have to answer all the questions. Section B, descriptive questions, where you will have some choice. Now coming to section A, multiple choice questions, for each correct answer you will get 2 marks. Understood? For wrong answer you will get 0 marks, no negative marking. Everyone, so first I'll read multiple choice questions. First question, what is the chief source of legal authority in India? The answer is Constitution of India. Second one, competency to contract relates to age of parties, soundness of mind of parties. Both age and soundness of mind, C is the correct option. Intelligence of parties is not a criteria to decide competency to contract. Okay, so C is the correct option. Next, 3, as per Sale of Goods Act, this is not included. So which is not included? Growing crop, money, table, goodwill. So money is not included. Money is not included. Next, Negotiable Instruments Act 1881 extends to only to capital cities of the state. Wrong option. Whole of India, correct option. Whole of India except the state of Jammu and Kashmir. Wrong answer. Whole of India except the Union Territories. Wrong answer. B is the correct option. Okay, so don't go with the answer given in the in this question paper, in the suggested answers, because in suggested answers you will find a D option, but D option is not correct. As per institute material also, B is the correct option. Is it clear, everyone? Next, where no provision is made by contract between the parties for the duration of their partnership or for the determination of their partnership, the partnership is called partnership at will. So fifth multiple choice question, the answer is partnership at will. If duration is not mentioned or determination of their partnership, if it is not mentioned, then that partnership, we call it as partnership at will. Next, what is the exact time limit under which LLP must file its annual return? The correct answer to this multiple choice question is option D. But as per your institute material and suggested answers of this paper, option A is the correct option. So go with option A. Understood? As a practicing professional, I know D is the correct option. But as per institute study material, A is the correct option. So go with option A. LLP must file its annual return within 30 days from the closure of its financial year. Is it clear? Next one. Employer shall display an abstract of the act and rules in form number U. Form number U. Next, following cannot be nominated for the purpose of EPF Act. So wife you can nominate, father-in-law you can nominate, unmarried daughter you can nominate, but sons of a deceased sons who have attained majority, this is not there. So option B, sons of a deceased sons who have attained majority cannot be nominated for the purpose of EPF Act. Next one, an appeal shall lie to High Court from the orders of ESI within how many days from the date of order of ESI court? And the option is 60 days. So within 60 days from the date of order of ESI court, an appeal shall lie to the High Court. Understood? Next one, the minimum rate of wages on time work basis may be fixed in accordance with by the hour, by the day, by the month. All the options are correct. So option D, all of the above is correct option. Next one, which public company is required to appoint independent director? The public company having turnover of 100 crores or more, the public company having paid up share capital of 10 crores or more, the public company which have in aggregate outstanding loans, debentures, deposits exceeding 50 crores or more, and D, any of the above. So the correct option is any of the above. So above mentioned companies are required to appoint a independent director. Next, following is the disadvantage of business ethics. There is only one disadvantage, that is diversity in achievements. So option D is the disadvantage of business ethics. Remaining all are advantages. Understood? Next, when the consent is caused by undue influence, the contract becomes voidable. So 13th option, option C is the correct answer. Next, dissolution of partnership means, it means dissolution of partnership between all the partners of a firm. It means change in the relations of the partners. So the appropriate answer is option B. It means reconstitution of the firm. See, out of 3 options, B is the best answer. B is the best option. Next, contribution of 10% to PF. Right now it is not 10%, it is 12%. Okay, so contribution of 10% to PF is applicable to any establishment in which less than 20 employees were employed, any establishment declared as sick industrial company, jute company, all of the above. So the right answer is all of the above. So above mentioned companies, yes, it is applicable. Is it clear? So multiple choice questions completed. Next, section B, descriptive questions. Contracts are legally enforceable, but every agreement may not be enforceable under law. Discuss with reason. So that means every contract is legally enforceable, but every agreement need not be legally enforceable. So discuss with reason. So here you have to write the requirements. See, an agreement which is legally enforceable, we call it as contract. Now to get legal enforceability, that agreement should fulfill certain requirements. So what are those requirements? You have to write all those requirements. So these points are very, very important. These points. There shall be an offer or proposal by one party and acceptance of proposal by other party. And there shall be an intention to create legal relations or an intent to create legal consequences. Next, agreement shall be supported by lawful consideration. Parties to the contract shall be competent to contract, and there shall be free consent between the parties to the contract. The object and consideration of the contract shall be legal. The terms of consent shall be certain. The agreement is capable of being performed and it is not impossible of being performed. Now the highlighted words are very important. You can write answer in your own words, but the highlighted words you have to reproduce as it is in the examination. See, I'm not telling you reproduce entire answer as per study material only. No, I'm not telling you. You can write answer in your own words, but these are the technical words you have to reproduce in the examination. Then only you can score good marks. Understood? Next, write one example. And next you can see here, an agreement not legally enforceable by law is said to be void. The following agreements are considered to be void. So what are those agreements? If consideration and objects are unlawful, agreements without consideration, agreement in restraint of marriage, agreement in restraint of trade, agreement in restraint of legal proceedings. Next, agreements uncertainty, agreements for uncertainty, agreement by way of wager. So write all these points. Then your answer is complete. So you can easily score 5 to 6 marks out of 7 marks. Next one, inspect whether an agreement by way of wager is a voidable contract or not. It is not a voidable contract, it is a void agreement. It is not a voidable contract, it is a void agreement. Understood? So if you observe the answer of 2B, it is very small. If you observe the answer of 2A, it is very big, right? So don't look at the content. Sir, if I write more number of points, I'll get more marks. If I write less number of points, I'll get less marks. No, it is not like that. In any question, if you had more than 7 points, try to attempt at least 7 points. Understood? In any question, if you had only some 2 to 3 points, then present answer completely. Understood? Suppose in one question there are 12 points. Now write at least 7 points so that you can easily score 5-6 marks. In another question, there are only some 2-3 points are there. Now write all those 2-3 points. Understood? And if possible, quote one example so that the valuer can easily get that point. Yes, you are having a subject knowledge. Understood, everyone? Section 30, sir. Compulsory. Is it compulsory to quote section numbers? Not at all compulsory. Not at all compulsory. You can write answer like this: as per provisions of, or according to the provisions of Indian Contract Act 1872. Yes, sufficient. Even if you write like this, sufficient. No need to write section numbers. If you are thorough with section numbers, if you are 100% confident regarding section numbers, then quote section numbers. If you are not confident, don't quote section numbers, because if you quote wrong sections, ultimately you may get less marks. Section 30 provides the agreements by way of wager or void, and no suit shall be brought for recovering anything alleged to be won or any wager or entrusted to any person to abide the result of any game or other uncertain event on which any wager is made. And we had one exception. Write that exception also. Is it clear? Yes, we are also having example. Write that example. So if answer is small, if you know example, then quote that example. So one point, if you are thorough with section numbers, if you are confident with section numbers, if you are confident with case laws, then only mention those case laws, then only mention those section numbers, or else ignore. Next, analyze the legal provision relating to modes of dissolution of a firm under section 39 of Indian Partnership Act 1932. So here you can observe modes of dissolution of firm. One is dissolution without any order of the court, that is voluntary dissolution. Here you can see dissolution by agreement. Next, compulsory dissolution. So try to cover all the points. Try to cover all the points. In each and every point, write sub points. Next, dissolution on happenings of certain contingencies. Dissolution by notice of partnership at will. Understood? Next one, dissolution by the order of court. So it is advisable to write all headings at one place. Yes, you can also draw a chart. The modes of dissolution of firm. 2 branches. Branch 1, dissolution without order of court or voluntary dissolution. So under that heading, you can write dissolution by agreement, compulsory dissolution. Next, dissolution on happening of certain contingencies, dissolution by notice of partnership at will. Second branch, you can write dissolution by the court. Understood? So with this chart gets completed. Now write each and every point. Write each and every point. Understood? 7 marks. You can easily score. Everyone. Next one. Make a comparative study between contract of sale and agreement to sell with example. So they are asking you differences between sale contract and agreement to sell. So whenever you find differences questions, try to present in this manner only. Basis, contract of sale, agreement to sell. Basis, contract of sale, agreement to sell. And try to write 7 points. Maximum 7 points sufficient. Is it clear? Next one. Chapter 5 provides the welfare measures to be taken in a factory. Examine the measures prescribed in the Factories Act 1948 to be provided by the factory to their workmen. So you have to observe the difference between welfare measures, safety measures. Some students, they will write safety measures instead of welfare measures. So there you can score only 0 marks. If you write like that, you can score only 0 marks. So don't get confused, welfare measures. First, you write all these sub points, washing facilities, facilities for storing and dry clothing. So like this, first write all headings at one place. Now, write each and every heading and just try to write 2-3 lines, point to one heading. So washing facilities. So don't quote section number. As usual, if you are confident with section numbers, quote section numbers, or else ignore. Okay. So separate and adequate screened facilities shall be provided for the use of male and female workers. The washing facilities shall be conveniently accessible and shall be kept clean. So writing 2-3 lines to each and every heading sufficient. Next, like that only, facilities for storing and dry clothing, facilities for sitting, first aid appliances. So here you can observe, first aid appliances. For every 150 workers at any time in the factory, you have to maintain first aid box. Next, more than 500 workers are employed. An ambulance of the prescribed size containing prescribed equipment, nursing staff shall be provided and made readily available at times. So if you find, if you are confident with respect to numbers, write those numbers and underline those points. So that valuer will go through those points and he will give you maximum marks. Understood? Don't ignore such kind of things. So these are the only things that differentiate a paper, best presented paper with common papers, and you will definitely score maximum marks. Next one, canteens, more than 250 workers. Next one, shelters, restrooms, lunchrooms, more than 150 workers. Next, crutches, 30 women workers. Next, welfare officers, 500 or more. So these points will also help you in attempting multiple choice questions. So these points you need to be confident. Next up, so just try to write 7 points. Next one, analyze the provisions relating to exemption given to the employer from the liability in certain cases from payment of gratuity under Gratuity Act 1972. So exemption from payment of Gratuity Act ma. So here 2 cases are there, 2 points are there. So you have to write all these 2 points. Used due diligence to enforce the execution of this act, and the other person committed the offense in question without his knowledge, consent, and convince that other person shall be convicted of the offense and shall be liable to like punishment as if he were the employer, and employer shall be discharged from any liability under this act in respect of such offenses. So these points are very important with respect to this answer. Next, fifth question. Describe about one-person company under section 2 clause 62 of Companies Act 2013. So one-person company for 7 marks. Now here you need to write everything about one-person company. Qualifications of a member, qualifications of a nominee, and one-person company advantages, one-person company disabilities, right? So you can't incorporate one-person company for carrying charitable activities, for carrying investment in body corporates. And next one, you cannot incorporate one-person company, as I told you, investment in body corporates, charitable activities, like that. So you have to write all these points. Another point is NBFC activities. So one-person company is not meant for carrying non-banking finance company activities. Next one, coming to the member qualifications, natural person. Next, Indian citizen, resident of India, period of stay at least 120 days in the preceding financial year. So all these points you have to cover in your answer booklet. Next, demonstrate the procedure for rotation of directors and reappointment of directors under Companies Act 2013. So complete procedure regarding rotation of directors. Again, reappointment of directors. You have to write both these points. First, rotation of directors. Next, reappointment of directors. So I told you 120 days, but as per your institute material, it is 182 days only. So you have to write 182 days. Right now, 120 days. Residential Indian resident, residential status is tested by checking whether his period of stay in the preceding financial year is 120 days or more. As per your institute material, 182 days. Just write 182 days only. Next one, as I told you, benefits of one-person company and provisions regarding nominee. And last one, penalty. Last one, penalty. If you cover all these areas, then you can score maximum marks. If you ignore any point, each point 1 mark less. Understood? Suppose you fail to write penalty. Now, your score will be some 4 to 5 marks. Understood? Next one. So procedure for rotation of directors. Next, reappointment of directors. So you have to write all these points. Understood? Next one, examine the applicability of audit committee. Applicability of audit committee, and it is given for 7 marks. Suppose if the question is tested for 2 marks, then simply writing first point is sufficient. Every listed company and prescribed class or classes of companies must have audit committee. 2 marks sufficient. But the question was asked for 7 marks. Now, simply writing applicability of audit committee alone is not sufficient. Here you need to write the functions of audit committee, the powers of audit committee, duties of audit committee, everything you have to cover in this question. Understood? So based on marks, you need to increase the content, but you have to write relevant content. You have to write relevant content. So here, when they ask you applicability of audit committee, simply writing first point, applicability of audit committee. Next, you're writing about appointment of auditor, reappointment of auditor, hours of auditor, duties of the auditor. If you write like that, you will not get good marks. You will get less marks. Are you all getting my point, students? If a question is asked for more marks, write relevant content with respect to that subject. Next one. Demonstrate the rights of shareholders under section 2 clause 55 of the Companies Act. So here you will find the rights of the shareholders. So all these points, some 12 points are there. Try to attempt at least some 8 to 10 points. Next one. Describe the concept of emotional intelligence. So this is from business ethics. So describe the concept of emotional intelligence. See here you will find 4 points: self-management, self-awareness, social awareness, relationship management. Write all these 4 points. Next you have to write 4 more points. If no emotional intelligence, if you are unable to control your emotions, then what are the disadvantages? How it is going to affect you at a school or work, how it is going to affect your physical health, how it is going to affect your mental health. Next one, so how it is going to affect the relationships. Like that you have to write all these points. So simply 7 points are there for 7 marks. Next one, explain what an internal code of ethics and its relevance in the business. So internal code of ethics, relevance in the business, just write this content according to CFAI website, members of CFA Institute. Just the following code of ethics. Write all these points. All these points. Next one. M, a legal successor of N, signs a bill of exchange in his own name, admitted a liability of 50,000 to the extent of which he inherits the assets from deceased payable P after 3 months from 1st January 2024. See, in the entire question paper, only one practical question came. Only one practical question, that is, 8th question. 8th question, 8A is a practical question. On maturity, when P presents the bill to M, M refuses to pay the bill. The liability was that of N, the limit in the bill, and the liability is more than the assets he inherits from N, the deceased. What do you infer from the case let? So this is the only practical question in the entire question paper. So if practical question comes in the examination, how to present? If a theory question comes in the present, direct the descriptive question comes into the present in the examination, how to present? Everything I'll tell you. Just wait. Next one, X was appointed as a director by AOA of a public company incorporated on 1st June 1970. The managing director empowered X to appoint a successor. X appointed Y as his successor after his death. Inspect whether Y succeed X as a director of the company or not. So this is also one more practical question. One more practical question. Understood? Understood? So just go through the answer of these 2 practical questions, ma. In the first question, in 8th one, first sub question, so 2 cases were mentioned. First one, he admitted liability of 50,000, and to the extent to which he inherits the assets from the deceased. Now in that case, his liability is restricted to the extent of assets he inherited from the deceased person. If nothing is mentioned, then he is liable for complete amount. Understood? Even though he got 30,000 value of assets, but his liability as per a promissory note, no negotiable instrument, is 50,000. In that case, he is liable for entire 50,000. In the first case, since he mentioned that his liability is limited to the extent of inherited assets, so there the liability is limited to the extent of assets he inherited from deceased person. Understood? Next one, second practical question. If you observe, assignment of director duties is void. Assignment of director duties is void. The company trusted you. See, company trusted X, and company named X as a managing director. Now only X can perform his duties. X cannot assign his powers. X cannot assign his duties to some other person. But in the question, if you observe clearly, the point is X deceased, X died. After the death of X, Y was appointed. Y was appointed as a successor of X. So here assignment is not happening. Understood? See, managing director X, he is alive, and he appointed someone to carry out his duties, to carry out his powers. Now that assignment is invalid. So if you remember this particular point you can easily attempt this question. And after everything, I made analysis of this model question paper, and accordingly I wrote this. See, paper 5, two sections are there as usual. Section A, 15 multiple choice questions, 2 marks is 30 marks. And section B, 7 theory questions are there, 7 descriptive questions are there. Out of 7, you need to attempt only 5 questions. So 2 questions you are having choice. So 5 questions, each question carries 14 marks, total 70 marks. And as per institute study material, we are having 4 sections. Section A, commercial laws. Section B, industrial laws. Section C, company laws. And section D, business ethics. And based on this model question paper, yes, I segregated total marks into section wise. From section A, from introduction to law, we got 2 marks multiple choice question, and 2 marks multiple choice questions from Indian Contract Act, and 2 7 marks question from Indian Contract Act. From Sale of Goods Act, we got 1 multiple choice question and 1 descriptive question. From Negotiable Instruments Act, we got 1 multiple choice question, 1 descriptive question. And next, from Indian Partnership Act, we got 2 multiple choice questions, 1 descriptive question. From LLP Act, we got 2 marks. See, I'm not telling you this is a final thing. So in final examination also, you'll get in this manner. I'm not telling you. I'm just segregating you to give one advice. Just listen. Next, from section B, from Factories Act, we got 1 descriptive question, 7 marks. Gratuity Act, 1 MCQ and 1 descriptive question. EPF Act, 2 multiple choice questions. ESI Act, 2 multiple choice questions. Code on Wages 2019, 2 marks multiple choice questions. Next, section C, 40%, Companies Act, we got 1 multiple choice question and 5 descriptive questions, each question 7 marks. And section D, Business Ethics, we got 1 multiple choice question with 2 marks and 2 descriptive questions with 7 marks each. So final subtotals, totals of each and every section. From section A, we got 51 marks. Section B, 24 marks. Section C, 37 marks, and section D, 16 marks. Sometimes what happened, here you'll find 7 marks, extra 7 marks in Companies Act and minus 7 in commercial laws. It will be like this only. It will be like this only. So this is like, some 40 plus or minus 7 commercial laws. Even in Companies Act also 40 plus or minus 7. Interchange is happening. Interchange is possible. Sometimes you may get more marks in commercial laws. Sometimes you may get more marks in Companies Act. Is it clear? And one more thing, even if you ignore one particular section, suppose section B, sir, section B, I didn't read, sir, or I'm not having time to revise section B, sir. Ignore, no problem. Why? Because, questions related to section B are coming in one question. Are you getting my point, students? Suppose if you observe question number 3, yes, we are having 2 sub questions, 3A, 3B. 3A, 3B belongs to only one section. It is not like this, 3A commercial laws, 3B company law, or 3A industrial laws, 3B ethics. It is not like this. In each and every question, you will find questions related to particular section only. Understood? Except last question, 8th question, if you observe, the combination is like this, one question from section A, other question from section C. It is possible. But remaining all questions, if you observe carefully, each and every question, you will find 2 sub questions, and these 2 sub questions are belonging to particular category, particular, section only. Section A, 2 questions. Section B, 2 questions. Section C, 2 questions. Section D, 2 questions. Like that we are getting. So even if you are not having sufficient time to revise all these sections, ignore one section, no problem. Even if you ignore section B, you can attempt maximum marks. Our question paper is for 128 marks, including choice. Including choice, it is for 128 marks. Even if you ignore, this section B, industrial laws, you are going to lose 1, 2, 3, 4, 5. So 5 into 2, multiple choice questions. So 10 marks you are going to lose, maximum, that is maximum. Descriptive questions, no problem. You can take that particular question choice and you can attempt remaining questions. Are you all getting my point, students? See, be thorough with these 2 sections, section C and section D. Particularly in section C, you should be thorough with the director's chapter. You should be thorough with the director's chapter and the last chapter, rights of the shareholders. Next, audit committee. So separate chapter is there regarding accounts and audit. So you should be thorough with those chapters. Is it clear, everyone? Next, regarding presentation, you'll be given additionals also. In examination hall, you'll be given additionals. It's not save paper, it's a save attempt. So don't try to save the paper. So your answer should be legible, understandable. Are you getting my point? So take a fresh page for each and every question and mark question, write question number in the center of the page like this, question number 1A. Question number 1A. Next, just leave one line gap, no problem. As I told you, it is not save paper, it is a save attempt. So just leave one line and then start your answer. Just to start your answer. In your answer, if you find points, suppose some 10 points are there, then write each and every point. After completion of each and every point, give one line gap. Just give one line gap. And in that point, if you find any technical word, sir, this word is very important to get more marks, sir, then highlight that word. Sir, for highlighting, what I should do? Should I use color, shall I use color pens? Not at all required. If you have pencil, just underline it. Sir, can I put scale and draw a straight line? Not at all required. Just normal, just draw it. That's it. Just to draw a line. That's it. Is it clear? So each and every point, give one line gap. Next, in each and every point, each and every statement, if you find this is a technical word, just underline it. One more time, I am telling you, you wrote exam for 3 hours. Do you think valuer will value your paper 3 hours? Do you think he will sit in front of your paper for 3 hours and he will value your paper? No. He will take, he will invest some 10 to 15 minutes on your paper. So during the 10 to 15 minutes, you should convey your valuer that subject. It is possible only with better presentment. Understood? Next one. So yes, second page, half page, you completed answer. And half page is available. Can I start a new question in that half page? No, ignore that half page. Take a fresh page. Again, yes, mark your question number at the center of the page, question number 1B. So like that, again, you start writing the answer. Suppose if it is a paragraph wise questions, after completion of one paragraph, just give one line gap, write another paragraph. If it is point wise, then write one point, give one line gap, write another point. Is it clear, everyone? Chalo, with this, I'll conclude this session. All the best for your upcoming examinations once again.